Evening, everybody. Happy Thursday night. We are going to wait a few minutes while folks join before we get started. Don't expect tonight will be much more than 30 minutes. We're going to give you an update on where we are. So just hang on for about 3 or 4 more minutes.
John, was it 40 in Texas today and going to be 80 tomorrow?
No, we had ice storm, so it was 24.
Good God.
And then we all stayed home. Got folks joining now. We're a couple minutes away from getting going. Q&A is open if you want to ask questions. We will be taking a stab at those tonight, like normal. So as we're getting ready to start, I just want you guys to see the screen in front of you that talks about where you can ask questions if you're not on a town hall at TCC questions at pscjlaw.com. You can also keep abreast of what's going on at the tccbsa.com website. We've been doing a lot of work on that. I think there's going to be some more videos up there that you're going to hear about tonight. So looks like slowing down a little bit. So Deb, why don't you go ahead and let's go. You got to put me in the thing.
You should be there, John.
Otherwise, it's going to be the Doug Kennedy show.
No, I think you're there. Go up to view and click gallery or something. I think you'll pop up.
Got it. Okay. So welcome, everybody. I have my Zoom coach, Doug Kennedy here, co-chair of TCC. And my name is John Humphrey. We're happy to see you all again. Hope everybody's staying safe and warm and that you're not in some war-torn part of the world. Just a quick reminder, my always disclaimer that we're not here to provide legal advice, and there's questions that you might ask that we may not answer and we may not be able to answer, but we'll do the best that we can. We've got our answer guys and gals online. So with that, we're not here to provide any individual legal advice. We're here to give you an update. There was a hearing today, so you're going to hear about that. And I would just say in opening, Doug, that it was a really good day for survivors. I think the fact that we got an independent trustee and a couple of real pros on claims administration was a huge breakthrough. And if you guys remember, the third leg of that stool was the independent trustee, because this trust is going to have billions of dollars in it, and we think it's important how that money's spent, and we think it's important that the money get out to you quickly. And we've always thought it was important that there was a degree of scrutiny so that the dollars got to the people who had legitimate claims. And so we've been working on that very, very hard, not to undermine youth protection or the opportunity to get more money, but just really pleased about that. So any thoughts, Doug, as we get started here?
Yeah, I agree, John. I think today was a good day, and we're going to talk about that a little bit more. We've been talking a lot on the TCC about our work and our role and how important it is for people to understand it. And I'm reminded of something that I tell my students every semester, and that is you are entitled to your opinion, but you aren't entitled to your facts. And I think it's important every now and then that we remind everyone that the TCC from its first day really saw its mission as advocating for all survivors and for educating and communicating. You know, we're coming up on almost 30 town halls. We have always said to survivors, here's how we're encouraging you to vote. Here's what we're recommending, but we just want you to vote. That's why we put out a voting video. And I think it's important to understand that the TCC is independent. I got to tell you, it's independent. We have 9 survivors. We've got our own individual attorneys that advise us, but we've got amazingly skilled and experienced professionals, attorneys, financial, insurance professionals as well, that advise us. And we ask brutally difficult questions, frank questions. We have TCC meetings where we're laser focused on doing what's best for all survivors. So we recognize that any settlement, any recommendation might, in your case personally, maybe you wish things were different. Maybe you wish our recommendation was different, but we're trying to advocate for what's best for all survivors and not leave any behind. And that's really important. And I can tell you, the other 8 men on this committee, I have seen them vote against their own personal interest to do what's best for all survivors. So if you have any notion that the TCC is selfish, acting on the interests of one group and not everyone, absolutely not the fact.
Yeah,
So,
you know, it's funny when I go back, Doug, and I think about when we all got together in Delaware, and they kind of roll called our names, and your stomach turns upside down, and you're thinking, what do I do now? I think the first thing that we did was we dismissed all of the professionals and decided we were going to get to know each other, because we knew that COVID was here and that we were going to meet virtually. And I don't know, you know, whether you guys value this backdrop, but, you know, these guys are just, you know, they're just volunteers. You know, we're all cobbling out a living, trying to take care of families, trying to go on vacations, doing all the same things that people do every day. And, you know, the unfortunate thing about the world we live in today is with social media and all of the channels for communicating, is that we've sort of forgotten the respect of the individual. And so we have, you know, when Doug talks about entitled to the facts, we've been knee deep in this stuff for a long time. And we told you that we were going to do the best that we could to get the youth protection in place, to get the most money that we could, and to put an independent trust together that would minimize expenses and maximize the output. And we think we've done that. Now, we certainly know there's people out there that have an opinion that, you know, the BSA should go away and that we should blow it up. And, you know, none of those things are even true. And nor would they result in you getting more money. So we think that the structure that we've put in place is the structure that gets you the money in the quickest possible way, in the fairest possible way. And look, it's not perfect. You know, nothing's perfect, but we're excited that we're at a place now where we can actually encourage you all to change your vote if you voted no, and vote to accept it. It came right down to the wire. And so with that, what I'd like to do is invite Rich Pacholski to come in and just share with us sort of what's been going on around governance. We had a hearing today, what happened there, and just get us up to speed, Rich.
Thanks so much, John. So I want to address a couple of things. As John and Doug have said, we had 3 legs to the stool. We feel that with respect to youth protection and compensation, we made tremendous progress. And the third was trust governance. And so when we spoke last week, which was the 17th, there were still interviews going on. It had not been disclosed yet. By Friday, the claims administrators had in fact been selected. The TCC stack members were very much involved, as were the coalition and one other who was an objector and has changed, what we call the Fau-Zalkin group. And the two claims administrators are a retired district court judge who was very involved in a number of sex abuse issues. He was a former district court judge from Illinois, and he retired and then started to do, I believe, arbitrations and mediations. And the other is a woman, and his name is Michael Reagan. There's also a woman by the name of Diane Welsh. Diane Welsh has a great deal of experience, particularly in the sex abuse area. And she was a former magistrate for the district court out of Eastern Pennsylvania. So they are two excellent choices. They will be overseeing the claims evaluation process. I believe Judge Reagan will be reviewing the independent review part, and that Judge Welsh is going to review the TDP part. As of last Friday, there was not a choice from the trustee. The process was still working. The debtor felt that it was taking too much time, gave the stack members time to work on it, but they did not come up with a consensus candidate. It came down to two candidates. One of them was one that, in particular, the TCC doing its evaluation was very supportive of. The other candidate was actually also qualified. But among other things, the TCC stack members, from what I understand, believe that the independent trustee that was chosen was going to be able to do it, for instance, full time, and has an impeccable record. Her name is Barbara Hauser. She was a former chief judge of the Bankruptcy Court based in Dallas. She has historically been the president of the National Conference of Bankruptcy Judges, which is a significant organization, obviously. And her most recent involvement was to be the lead mediation judge among, I believe there were 5 total judges, to try to mediate the Commonwealth of Puerto Rico's restructuring, which she completed in a way that she would now be able to work on Boy Scouts, because she retired effective February 1st. And if you do research on her, you will find that she's extraordinarily bright, independent, highest integrity, and will do a great job of managing this trust. And why the claims administrators and independent trustee were so critical to the TCC was to make sure that distributions would occur to survivors as soon as practicable, considering the number of survivors and the number of claims that are going to be dealt with through the independent review and the TDP. And so I can tell you, as someone who has evaluated the credentials of these parties, I don't think that the trust could have a better governance system, and particularly in terms of independence and competence. So I'm excited about that. I think the TCC members are excited, and I believe that the issue came up today in court, as Doug had referred to, because there had not been a choice of a trustee as of today. It actually happened this morning, but the various insurers had written a letter to the judge saying that the trustee had not been selected and was supposed to be selected last week. And the judge had set a status conference. At the status conference, the debtor had confirmed that that Judge Hauser would be the trustee that they were designating for purposes of the plan. And the judge accepted that today. So at least we know who the independent trustee and the independent claims administrators are going to be on a going forward basis. So I think that was a very, very good thing for survivors. Because of a prior hearing, as people know, we were supposed to start trial on January 24th. It got moved to February 22nd. And then again, because of the settlement that had been reached among the TCC, the coalition, the debtors, and the FCR, and one of the objecting parties, the Fau-Zalkin group, the February 22nd was frankly moved to March 9th. And because of additional work that was being done, it has now been moved to March 14th. So the trial should start on March 14th. I don't see it moving from then. And just so everybody is aware, it doesn't end the mediation. There are insurers and charters that have not settled. There are mediations going forward, but to be clear, as I mentioned last week, that the settlements are conditioned on the agreement of all of the groups that participated in the settlement, not the least of which is the TCC. So one of the major issues that we were able to deal with through the mediation process is we felt settlements were being entered into that were not favorable to the survivors. And now if another settlement comes forward up through the effective date until the trustee is in place, any of the representatives, including the TCC, can veto it. And so there has been no settlement that has been entered into since, I believe, third week of December. And if it's brought forward to the TCC will either decide it works or it doesn't. And we can try to move forward and feel comfortable that we won't have a number of bad settlements that are not appropriately reviewed. So I think Doug and John, that's, I believe, where we are right now, unless you have any further questions, but I think we're in a
It's
good
very
spot.
exciting. I mean, doing the judicial review on Puerto Rico, pretty big deal. So as far as changing votes, Doug, do you and John Lucas want to talk about how people go about doing that and give some instruction? Because I know you've got a video that you've put together. And
Well, we've got a video on that. It's one of our questions later on, John, but why don't I let John Lucas just touch on that briefly?
okay.
Hey, hello, everybody, and good evening. And we're going to talk again a little about changing votes, which we did last week. And Deborah, if you could, maybe you could put up the vote slides. There we go, everybody. So how do I change my vote? So number one, if you're represented by an attorney and your attorney voted for you through what we call a master ballot, and you didn't get the ballot yourself, then you should contact your attorney and discuss the plan and the revised plan with your attorney and make a decision with your attorney on how you want to change your vote. The TCC now, in light of the new plan, the TCC is recommending everybody to change their votes to accept. And, we're encouraging everybody to change their votes to accept. And so instruct your attorney in writing, use an email as the most quickest way to change your vote, or instruct your attorney to create a record. You could also do it by telephone, and your attorney will take down a record of the conversation and mark the master ballot and send it in to Omni, the voting agent, by 4 p.m. on March 7th, 4 p.m. Eastern time. And so the next slide, please, Deborah. So if you voted yourself and you got an individual ballot and you don't still have your blank ballot that you used before, then you need to email Omni, and we will get to the email address, and you can get a new ballot and you'll get one in an email, and you could either mail it to Omni or you could upload it to the claim portal. But in that ballot, you need to do a couple of things. You need to make the election to either accept or reject. And as I said, the TCC is encouraging everybody to accept the plan. And you need to decide whether or not you want to make the $3,500 distribution if you want just that. And so if you said you wanted the $3,500 distribution before, you could just not do it this time and leave the box unchecked. Or if you didn't do it last time, you could check the box this time. As for the opt-out, we're recommending that people check the opt-out box, fill in all the personal information in there, your name and your address, the last 4 digits of your social security number, and most importantly, sign it. And it needs to be received by Omni by 4 p.m. Eastern on March 7th. And here come the details of where it's going to go. Completed and signed, that's the address. And the website there on the bottom is where you could upload your ballot. This slide deck here that we're going through is on our website at tccbsa.com. You got questions about voting? We encourage you to first ask your counsel if you have them, but if you've got basic, just sort of logistical questions, send them to us. If you need a ballot, BSA ballots at omnimanagement.com is the place where you can get your ballots. You could obviously write to Omni, but we don't recommend it because we think it's going to take too long to the best. And if you're having some other issues, get in touch with us and we could help Omni get you a ballot also.
And John, it's probably a good time for us to remind everybody that these videos of all our town halls will be posted on the website. So if you've been scrolling furiously, you'll be able to go back and pick all this up.
Yeah, and that little sort of few pages that we went through with the information on it is also posted on the website. And all that information is there. And anybody who is asking questions about that through TCC questions at pscjlaw.com should be able to get an answer through that way too.
Thanks, Sean. Thanks, Doug.
Yep.
So listen, folks, some of you are asking what's different, why were we so adamantly, and if you go through all the things, there was a video of Doug and I sitting on a dock, objecting to things. And so why now? Well, I would tell you that the no votes that you guys put in absolutely allowed us to get back at the table. We had no controller power in the trust. We were stalled on youth protection. And we not only weren't at the dollar amount that we wanted, but we had no veto rights over settlements as they came in. And they were coming in and there were some lowball things that got, slipped through the cracks. And so we've addressed all of those things. Now, why stay no? If you want to go it alone someday and vote to object on this thing, and you think you can go into the local courts that are all backed up for years based on COVID, that's a big risk. And so what we tried to figure out is what is in the best interest of all 82,500 survivors so that everybody has the opportunity to get something. And so this is why now we're asking you to vote to accept it and spread the word, let people know that you did. And, Rich, I think we've already covered some of the governance issues, so I think we should go to Q&A. Is that okay with everybody?
I think that makes sense.
Okay. So, Doug, you want to lead us through some of the questions that we've sort of accumulated over the last?
Yeah, sure. Jim, one of the things that we hear, questions that we hear is, wouldn't we be better off if the BSA liquidated, if they just went out of business and we got the hands on all their assets? And that's kind of a two-part question, how liquidation works, but also if something like that ever happened, why would that not be a good thing for survivors?
Thanks, Doug, and good evening, everybody. First, the bankruptcy court does not have the authority to force the Boy Scouts into a liquidation proceeding, which bankruptcy lawyers sometimes refer to as Chapter 7, which is Chapter 7 of the Bankruptcy Code. Because the Boy Scouts would qualify as a nonprofit, some people use the term non-moneyed corporation, the statute is absolutely clear. The Boy Scouts cannot be forced into a Chapter 7 liquidation proceeding. The court does not have the power to do it. So liquidation is, in a sense, a hypothetical. We'll get into liquidity and the resources of the Boy Scouts in a few minutes in terms of them going forward. But let's pretend that for one reason or another, the Boy Scouts did liquidate, even in with the context of the existing Chapter 11. Because converting the case to a Chapter 7 forces the liquidation, but in a Chapter 11, corporations liquidate all the time. Is that good or bad for survivors? The TCC did an extremely deep dive into the assets of the Boy Scouts of America. We looked at their cash, its cash, its investments, its real estate, including valuation of real estate. The deep dive included a review of what we call donor restrictions. I hereby give the Boy Scouts $10,000 to be used only for the operation of Camp X. Yeah, that restriction is binding on creditors. And so the BSA, or creditors of the BSA, do not have the ability to break that restriction. But we looked at them very hard. If it said, I'd like that money to go to Camp X, we considered that unrestricted. But people have a right to dispose of their property the way they want. And we looked hard at the restrictions in evaluating what could be obtained from BSA in liquidation. And that includes the endowment that the BSA has and a foundation that the BSA has. We also looked very hard at the high adventure facilities. And those adventure facilities were appraised, and they are subject to mortgages from JP Morgan in amounts that far exceed the value of the high adventure facilities. Now, I don't think JP Morgan was making a gift to anybody, but the facts are that the value of that real estate is less than the mortgage. And so a sale of the high adventure facilities based on appraisals would not yield anything to survivors. In addition, JP Morgan, by virtue of certain bankruptcy protections that it obtained at the beginning of the case, also may have claims against some of the cash and investments that would otherwise be able to go to us, the unsecured creditors. So at the BSA level, we did a really, really deep dive into their assets and concluded that it's not really where the big value is, folks. It's not at BSA National. The value is, if anywhere, relatively speaking, at the local councils. I did see a question in the Q&A about the artwork. The settlement trust is getting the artwork. Judge Hauser, when she's confirmed as the settlement trustee, will be in charge of liquidating it. And we have spent some time over the last year and a half plus looking at the market and contacting people for the eventuality of when that artwork would become available. So now let's talk about the local councils. In a BSA liquidation, the local councils will in effect have their charters terminated. These are annual charters. They go away at the end of whatever year is left. What happens to those local council assets? Well, we have been told by the local council ad hoc committee that many of the local councils will file bankruptcies. So that has its attendant delay. That has its attendant cost. Under the governance documents of the Boy Scouts, if the charter is revoked, the assets of the local councils get liquidated for the benefit of that local council's creditors, not for the benefit of survivors as a whole. And so if you're looking at the goal of this case to be a fair settlement for all survivors, the liquidation of the Boy Scouts with the loss of the charters to the local councils simply does not accomplish that. So that's the answer. We don't think, on paper, one could make an argument that the liquidation numbers turn out to be different. Oh, by the way, there's also a claim by the Pension Benefit Guarantee Corporation, which is, at least according to its analysis, in excess of $1 billion that is against all of the local councils and the BSA, not $1 billion for each, but $1 billion in total. And that would clearly dilute recoveries from survivors. All these positions can be contested, but at the end of the day, as John and Doug have said, we had to make a decision. And that was what is in the best interest of survivors. And with the changes that were accomplished because of the power of no, your no vote, we came to the conclusion, we meaning the TCC, came to the conclusion that it was time to vote to accept the plan.
I know I saw a number of questions in the Q&A, and we had harvested this one, Rich. It's what happens with the insurers who have not settled?
Okay, John, that's a very fair question. And frankly, it's one of the major reasons that the TCC ultimately decided to enter into a settlement, because what we were seeing was that there were settlements that we did not we're not pleased with. And frankly, we didn't see that that was going to stop. And the choice was to continue to see settlements that we didn't find favorable. And ultimately, a plan was confirmed that was a lot worse than we might be able to do vis-a-vis a settlement. So let me kind of explain the answer in this respect, because there are different periods of time. From now until the effective date, and this is a critical issue in my view, there can be no settlement without the approval, among others, of the TCC. We have veto power. Now, we're not going to just use it to veto if the mediator, who's, I understand, continuing to try to mediate with insurance companies and charters, if the mediator comes up with a fair settlement, we evaluate it, we can analyze the claims, then we will support it. If we do not believe that's the case, then we will veto it. And so that will go forward until the effective date, which, assuming the plan is confirmed, will be somewhere in the probably in the second quarter of this year. After the effective date, one of two things will happen. Either the independent trustee will negotiate with the insurance companies. There will be a presentation to the stack members, and the stack members can go ahead and approve the settlement. That is one approach, and that would be the favorite approach. On the other hand, if negotiations take place or do not take place, and the independent trustee makes a determination that it's not worth trying to negotiate anymore, there will be litigation against the insurance company, and the settlement trustee will push as hard as possible to try to get a favorable ruling from the court. And so there are mechanisms in place before confirmation of a plan and post confirmation of a plan, so that the insurance settlements will be thoughtfully either resolved through settlement or resolved through litigation. And that's how it's going to be going forward.
Thanks. And there was another question to that vein. We can't go back to Century or Hartford and improve those deals at all.
That's a great question. I know a lot of people have asked it. So here's the reality. We had to make what was in the best interest of the survivors. We were not satisfied with some of the settlements. There's no question about it. We could have just said, we are going to oppose, and that would have been an option. And settlements would have, in my view, continued on. And we would have been even angrier than we were based on the past settlements. So like anything else, you have to look at a cost benefit analysis. There was still billions of dollars of potential insurance, and we didn't want to lose that opportunity. And yes, we had come to the conclusion that the settlements that had come through were lower than they should have been, but there was not a reality of getting a veto right or a better structure on future settlements and changing the past. The Boy Scouts, the local councils, the insurance companies who had been involved would have never allowed that. And so this wasn't like, let's get a better deal and let's negotiate a great deal in the future. To put it in a simple way, it was binary. We could either accept what was there and protect the future, or object to any settlements, including new settlements that were going through mediation. And I think the decision was made, which I think was the absolute right decision under the circumstances, to go forward and make an arrangement to protect the future, even if we couldn't change the past.
And by protecting, that means we can go, there's still substantially more money to go get.
We think there's substantially more money to get, both in primary insurance and excess insurance. And I was very nervous that the vast majority of that would have been settled in a way that we would have found very unfavorable.
I was going to say, John, the other wrinkle to Rich's point is the more time we spent negotiation, the more of the Boy Scouts money was going to be spent on bankruptcy and kept out of the hands of survivors. And quite frankly, we had survivors that we were concerned about them living through this bankruptcy as well. So it's, just waiting would not have been the right strategy either. But I think this also leads to the next question for Jim, and you touched on a little bit before, Jim, but what about the notion of getting more money from the chartering organizations or the local councils? And I think probably we need to explain what's going to happen with the charter organizations at this point.
So I saw a question that said, why don't we just get X thousands of dollars from the 40,000 chartering organizations? And that adds up to, and there was several billions of dollars was in the question. And I guess my answer to that is from your mouth to God's ears. Think about it, folks. 40,000 chartering organizations that are going to be pursued in state court, which, as John pointed out, almost every civil docket in the country is backed up several years with COVID, chasing organizations that whose assets, by the way, have not really been analyzed by anyone. And so I understand that if everyone put in X thousands of dollars, it adds up to a lot of money, but that is chasing a lot of cats. So the plan provides for releases for certain chartering organizations. And I think that rather than going into an explanation of which ones are getting released and which ones aren't, probably best left to something on the website so people could understand it. But there is an enormous, from the perspective of trying to negotiate a settlement with that group in the context of the bankruptcy, that was a task that Herculean doesn't begin to describe it. Frankly, I think it was impossible. We saw some ad hoc committees formed. There's a Roman Catholic ad hoc committee. There is the Methodist. I don't know if they had an ad hoc committee, but they were negotiating. And so certain groups were able to kind of pull it together and negotiate as a group, but it just did not appear to be to us to be cost effective to try to do it in a collective way at the bankruptcy level.
Okay. Doug, anything else from you?
Well, the only thing I want to add to this is we've seen a lot written about why it's going to cost $20,000 for a review and a lot of confusion about the review process. So a couple days ago, John Lucas and I put together a video. The trust distribution process, the review process is complicated. It's nothing you can explain in just a few minutes. So we put together a video that is about 50 minutes long. And we had a great suggestion to put some sort of a timestamp on it so that survivors could go back and go to minute number 43, for example. So we wanted to get that up tonight. Apologies. Hopefully it's going to be up tomorrow on the website. And we really think that's going to be a good video. It's basically John Lucas, who understands this far better than I ever could, answering my questions as we run through it. But we really think it's going to help to explain the 3 paths that are part of the review process for claims and answer a lot of questions. Again, we know it's lengthy, but this is important stuff that can't be just glossed over.
Yeah, listen, there's lots of opportunity to have somebody listen to your desire to improve your claim. This $20,000 number is a lightning rod that everybody seems to be rallied emotionally around, but there are several other ways before you even get to that. And the video is great. It goes through all the details. So if that's something you're concerned about, then check out TCC BSA over the next few days, and we should have all the updates, including the recording for this. So with that, I think we're going to wrap for the night. If you have questions, TCC questions at pscjlaw.com. Remember that the voting deadline is new. Last week it was March the 4th. This week it's been extended to March the 7th. That means that your ballot needs to be at Omni by 4 p.m. Eastern Standard Time. So if you have any questions, reach out to us. I'd just like to thank everybody for being here tonight. Thanks for all the participation. Keep an eye on the website, and we'll see you next time.
Stay strong, everybody.